the government change the rules after you'd already been playing by them for years? What if you gave up opportunities in your home country, built a life in Britain, paid your taxes, contributed to your community, and then were told the finish line had been moved? Not for newcomers, for you, right now, today. That is exactly what tens of thousands of international workers across the United Kingdom are facing. And something has just happened in Parliament that could change everything, or change nothing at all. I'm going to give you the full picture, the uncomfortable truth, and exactly what you need to do right now. Stay with me, because this is the most important update on the ILR debate yet. Welcome back to GoUKGo. If you are an international worker in the UK, or you know someone who is, the next few minutes could genuinely shape the decisions you make over the coming weeks. Because this week, the political pressure on the government's proposed ILR changes reached a level that nobody expected. 35 Labour members of Parliament, members of the governing party, the same party that put the Home Secretary in her position, signed an open letter directly to Home Secretary Shabana Mahmood, telling her in no uncertain terms that the proposed changes to indefinite leave to remain must not be applied to people already living and working in the United Kingdom. And they did not stand alone. They were joined by 17 MPs from other parties, 21 peers from the House of Lords, and 33 civil society organizations, including representatives from Unison, the UK's largest trade union. This is now the most significant and coordinated political rebellion against these proposals we have seen throughout this entire debate. But here is what makes this moment so urgent and why you cannot afford to look away. The public consultation on these proposals closed on the 12th of February. The government is right now, as you watch this, reviewing every single response they received. The hundreds of thousands of petition signatures, the legal submissions, the expert evidence. A final decision is expected by the end of March or early April. Not months away, weeks. The window to influence this policy is closing at speed, and every international worker in this country needs to understand the real state of play. Not just the optimistic headlines, but the full, honest picture. So let me break it all down for you. Let's start with the letter itself, because the language used is striking. Coordinated by Labour MP Neil Duncan Jordan and sent directly to the Home Secretary, it describes the proposed changes as deeply unfair towards international workers who have, in the letter's own words, put down roots, contributed to their community, and built their lives here in the United Kingdom. It labels the retrospective application of these new rules as un-British, a loaded phrase that is deliberate and pointed. It accuses the government of moving the goalposts on people who have done everything asked of them. And it makes one specific, unambiguous demand. The government must immediately rule out applying any new immigration timeline to people who are already in the UK. Now, some people have been quick to dismiss this, saying the government will simply do what it wants regardless. I want to address that directly because the parliamentary reality is more complicated than that. In the British political system, the government needs its own MPs to vote for its legislation. If 35 Labour MPs feel strongly enough to publicly put their names to a letter opposing their own government's flagship immigration policy, those are potentially 35 votes the government cannot count on when this comes before Parliament. Add the 17 MPs from other parties who co-signed, combine them with opposition MPs who already oppose these changes on principle, and the government's ability to comfortably pass this legislation suddenly looks a great deal less certain than it did a month ago. Prime ministers and home secretaries do not lose sleep over polite disagreement. They lose sleep over rebellions that threaten to derail legislation. The Home Secretary knows the arithmetic here, and that is precisely why this letter carries genuine political weight. The letter also makes an argument that cuts across political lines, and I think it is one of the most powerful statements in this entire debate. It says the British public believe in fair play, that if you work hard, follow the rules, and contribute, the government should tread lightly on your life. That is not a left-wing or right-wing argument. It is an appeal to something most British people, regardless of their politics, instinctively believe in. You honor your commitments. You do not change the rules on people who have already been living by them. You keep your promises. The moment a government is seen to move the goalposts on people who acted in good faith, It corrodes something fundamental in the relationship between the state and the people it governs. The letter also raises the social care crisis, and rightly so, because it is impossible to have an honest conversation about these proposals without confronting what they would mean for that sector. The UK already has thousands of unfilled vacancies in social care. Care homes are already struggling to maintain adequate staffing. Elderly and vulnerable people across the country are already waiting longer than they should for the support they need. The proposals under discussion would require care workers to wait 15 years before they can apply for settlement. 15 years of tied employment, 15 years of uncertainty, 15 years of knowing that your right to remain in this country is entirely dependent on your employer's behavior, compliance record, and commercial survival. The letter warns these proposals will push the care sector closer to breaking point, and many professionals in that sector would tell you it is already there. If thousands of dedicated care workers decide that 15 years of this level of precariousness simply is not worth it, and leave or never come to the UK in the first place, the consequences for the most vulnerable people in British society will be immediate, profound, and devastating. Now, here is the reality check that every person who felt hopeful after reading about this rebellion genuinely needs to hear. I have been watching every interview the Home Secretary has given since this political pressure began building. And while MPs have been writing letters, while unions have been filing petitions, while legal experts have been giving evidence to parliamentary committees, Shabana Mahmood has been remarkably, almost stubbornly consistent in her position. She said directly in a recent interview that she believes it is, and I am quoting her words, unreasonable to say a few people in the UK will not be impacted by this policy. Read that slowly. She is not saying she will protect people already here. She is saying that exempting them is unreasonable. That is not the language of a minister preparing to make a major concession. The political pressure is real, and the rebellion is significant. But you must balance that hope with a clear-eyed understanding of what the person who will ultimately make this decision has been saying out loud, in public, on camera. There is something else happening right now that I believe is being dramatically underreported in all the coverage of this ILR debate, and it is causing real, immediate harm to international workers, regardless of what the final ILR decision turns out to be. Sponsor license revocations. While the entire focus of the media, the campaigns, and the political debate has been on whether settlement takes 5, 10, or 15 years, the Home Office has been systematically revoking sponsor licenses from companies and organizations across the UK. And when a company loses its sponsor license, every skilled worker, every health and care visa holder they sponsor, is immediately placed in a terrifying race against time. They are given 60 days. 60 days to find a new employer with an active license, secure a new sponsorship offer, navigate the full visa transfer process, and maintain their legal status, or leave the country. In a market where many care sector employers are already reluctant to take on the costs and compliance obligations of sponsorship, this is not a theoretical risk. This is happening to real people, right now, today. And in many of these cases, the worker did absolutely nothing wrong. Their employer failed a compliance inspection. Their employer had documentation issues. In some cases, the Home Office found fraudulent activity elsewhere in the organization. The worker is punished for the employer's failure, having built their life in good faith, followed every rule, and done everything right. Here is where this connects to the ILR timeline debate in a way that should alarm everyone. If the government extends the settlement timeline to 10 or 15 years, it extends the period of employer dependency to 10 or 15 years as well. That means a decade or more of knowing that if your company loses its license, faces financial difficulties, restructures, or simply no longer wants the burden of sponsorship, you have 60 days and then you are potentially gone. The combination of an extended timeline and precarious sponsorship creates conditions ripe for exploitation. Some employers understand exactly how dependent their sponsored workers are on them. Some use that dependency to suppress wages, demand excessive hours, and resist legitimate complaints. 5 years of that vulnerability was already a serious concern. 10 or 15 years is unconscionable. So where does all of this leave you? The consultation is closed. The government is reviewing responses. A final decision is expected by end of March or early April. If you are approaching your 5-year ILR eligibility date under the current rules, do not wait to see what the government decides. Get your documentation in order now. Make sure your continuous residence is provable, your English language requirement is satisfied, and that you are fully ready to submit your application the moment you become eligible. Do not delay. If you are further from your eligibility date and on a sponsored visa, check the status of your employer's sponsor license on the Home Office register today. Not when you receive a curtailment letter, today. Knowledge is protection. And if you are considering major long-term financial decisions, a mortgage, a career move, a significant investment, it is entirely reasonable to wait a matter of weeks until the government announces its final decision before making commitments that are difficult to reverse. The honest assessment of where things stand is this. The labor rebellion is genuinely significant and could influence the final outcome, particularly around transitional protections for people already partway through the current 5-year route. But the Home Secretary's public statements should temper expectations. The most likely outcome is some form of compromise. Transitional protection for those closest to the 5-year mark, combined with an extended timeline for new applicants. But that is political analysis, not confirmed policy. The government will tell us what they have decided by end of March. That is the real state of play, laid out as clearly and honestly as I can give it to you. At GoUKGo, our commitment to you is always the full picture. Not just the headlines that feel good, but the complete truth so you can make informed decisions about your life and your future. If this update gave you real clarity on where this debate stands, hit that like button right now and share this with every international worker you know in the UK, because the March deadline is approaching fast and everyone needs to understand what is really happening. Subscribe and turn on notifications because the moment the government's final decision is published, we will be here, breaking down exactly what it means for every visa category, what protections exist, and what your options are. Drop a comment below and tell us what you genuinely think. Is this labor rebellion real pressure that will change the Home Secretary's mind? Or is it political cover while the government quietly moves forward with its original plans? Every comment gets read, and your perspective matters to this community. Until the decision drops, stay informed, keep your documentation ready, know your employer's license status, and remember this: the answer is coming in weeks, not months. Be ready for whatever it says. This is GoUKGo, and we'll see you in the next one.